Good day, ladies and gentlemen, and welcome to the Patent Law webinar. I would now like to turn it over to Ms. Jennifer Sklenar. Please proceed.
So with that, let's turn to the subject matter of the presentation. I am going to go first and talk about some issues of patent-eligible subject matter and patent exhaustion, and then we will have Monty Agarwal, who is going to be talking about induced infringement, and then Mike Berta, who will be talking about patent damages issues, and finally, last but not least, Tom Magnani, who will be talking about implied licensing issues. I also wanted to mention that we have a program tomorrow in person in Los Angeles, also available by webinar, which will focus on trust IP issues in a similar type of way. So with that, let me turn to the first topic, patent-eligible subject matter. And this, as I'm sure many of you know, is an issue that's of great importance and interest to the U.S. Supreme Court. The Supreme Court is active in this area. There was a case last term that I'm going to talk about, the Mayo or the Prometheus decision that involves laws of nature. There's the case that the Supreme Court is looking at coming up involving aspects of human genes. This is an area that raises not only constitutional issues and statutory issues, but also issues of public policy and morality. Jonas Salk was famously asked in the mid-50s by Edward R. Murrow, who owns the patent on the polio vaccine? And he famously answered, there is no patent. Could you patent the sun? And now the story goes that actually the lawyers at the Salk Institute did look into patenting the polio vaccine, but thought that they had prior art issues, and for that reason they didn't do that. Whether that's true or not, this sentiment that's expressed by Dr. Salk is one that we often come upon, and it's essentially a sentiment that's argued quite a lot in these cases. So with that, let me turn to the Mayo versus Prometheus case. The patent claims there were in the diagnostic space. There were claims that were method claims, and it's important that these were method claims because that may matter for some of the case law later. But there were claims to assist doctors determine the appropriate dosage of thiopurine drugs to treat patients with autoimmune diseases such as Crohn's disease. And Mayo, was the accused infringer. It had been buying the test from Prometheus and using and selling their test for quite a while, but then the Mayo entities, including like the Mayo Clinic in Rochester, wanted to sell and began using and selling their own test. It was somewhat different, but still arguably fell within the scope of Prometheus's patent claims. So Mayo was sued for patent infringement, and it raised the Section 101 challenge. And there the issue was that the claims touched on a law of nature, which was the relationship in the blood of certain thiopurate metabolites, and the likelihood that a dosage would be effective or result in side effects. So this issue made its way to the Supreme Court, and how did the Supreme Court decide this issue? In a 9-0 opinion written by Justice Breyer, the Supreme Court first looked at the competing legal principles. And those are that laws of nature, natural phenomena, and abstract ideas are not patentable. But on the other hand, an application of a law of nature or mathematical formula could be patentable. The court also looked at the competing public policy, which is that you don't want the grant of a patent to tie up laws of nature and inhibit future innovation, but you also want to reward those who make discoveries and innovate. So to decide the issue, the court dove into a typical patent claim, and it was agreed that this claim that you see here, Claim 1, was representative. And the court looked at the limitations. There was a step dealing with administering the drug. There was a step dealing with determining the metabolite level in the blood. And then there were wear-in clauses where the certain metabolite levels indicated a need to increase or decrease subsequent administrations of the drug. And the Supreme Court put it this way. The question before us is whether the claims do significantly more than simply describe the law of nature. Do they add enough beyond their statements of the correlations to allow the processes to qualify as patent-eligible processes? Went on to say we believe the answer is no, because any additional activity in the claim beyond the law of nature was well understood, routine, conventional activity already engaged in by the scientific community. So The question that we will have going forward is whether courts apply this to other types of subject matter beyond laws of nature, and whether this is applied to composition of matter claims. We don't have to wait very long to see what will happen in that regard, because that takes us to the Myriad case. Now, Myriad is a case that you all know has probably done a lot of publicity. The claims there involve aspects of the BRCA1 and BRCA2 breast cancer genes. Basically, it was discovered that alterations in these genes indicate a propensity of women to have breast or ovarian cancer. Myriad, who was the patent holder in this case, had done quite a lot of work and put a lot of money into sequencing these genes and patented various aspects of it. Myriad also had an aggressive history of enforcing their patent rights. And essentially what they did was try to prevent anyone else from providing commercial diagnostic services to see whether women had alterations in these genes. And there were a number of issues that were raised. They were selling the test at quite a lot of money. They weren't taking all forms of insurance. And essentially the argument was raised that if a woman got a positive test result and was considering something drastic like a mastectomy, the patent rights foreclosed women from getting a second opinion, from going to somebody else to get the test done. And so there were a lot of plaintiffs who joined this case. There were medical associations, patients, doctors, and the petition to the Supreme Court was being funded by the ACLU and the Public Patent Foundation. The Supreme Court indicated just a couple of months ago that it will hear this case and it will decide question number 1, which is phrased as, are human genes patentable? So let's look at the Federal Circuit decision, because this is obviously what the Supreme Court is going to review. The Federal Circuit looked at this case twice. It decided the case once, and then it went up to the Supreme Court, who remanded it in view of the Mayo decision. The second decision was 2-1, authored by Judge Lori, and there the Federal Circuit reversed in part and affirmed in part on the issue of patent-eligible subject matter in view of Mayo versus Prometheus. And here, there were 3 different sets of claims that were at issue. There were composition of matter claims that were directed to the genes themselves. The Federal Circuit held that those were patent eligible and were available for patenting. There were method claims directed to screening potential cancer therapeutics by assessing changes in the cell growth rates of transformed cells, also patent eligible. And then there were method claims directed to comparing or analyzing DNA sequences, which were held to be patent ineligible. Now, I'm going to focus on the composition of matter claims because that's really where most of the controversy lies, and that's what the Supreme Court is going to decide. For the composition of matter claims, there were actually three different types. There were the isolated DNA claims. And isolated DNA, for those of you who don't know, is basically a process whereby DNA has to be extracted from the cell, separated from proteins, other genomic materials. It's a complicated process, very labor-intensive. There were also claims directed to shorter molecules that could be used with things like probes and primers that corresponded to portions of the gene. And then there were cDNA molecules, which are man-made, but have some correlation to the native DNA, but there's a difference in that it excludes the intron portion of the DNA sequences. So on the first type of claim, isolated DNA, there was a lot of controversy about this at the Federal Circuit level. Judge Lori held that it was absolutely patent-eligible subject matter. He viewed isolated DNA as man-made, as a composition of matter, and said that it was markedly different than native DNA, and that was a relevant test because of some earlier Supreme Court case law. He viewed the Mayo decision as simply irrelevant because we're not talking about a law of nature, a product of nature, we're talking about a man-made material. Judge Moore thought it was a very difficult question, but she concurred because of settled expectations, citing things like the fact that patents have been granted on isolated DNA for many, many years. There were USPTO guidelines that said that the subject matter could be patented. There were in excess of 2,500 patents that had been granted covering the subject matter. And she also noted that there was evidence that Congress was well aware of this practice and had failed to act. And then we had Judge Bryson, who dissented and felt diametrically opposed on this issue than Judge Lori. he said that essentially Myriad is claiming the gene itself and thought that isolated DNA was not materially different than the native DNA. And then we have the government who was involved. And interestingly, the government did not try to defend the USPTO examination guidelines. Instead, the government advocated what it called in oral argument a magic microscope test, which I find fascinating. And that test is that if you could imagine a magic microscope and put it inside a human body, if you could find in the human body the subject matter of the claims, it can't be patent-eligible subject matter. And that was how the government viewed isolated DNA. As far as the other types of claims, the shorter molecules that could be used as things like primers and probes, there was again debate as to whether that was patent-eligible. But then interestingly, for the cDNA molecules, which are man-made but have some correlation, there was agreement among the panel members and also the government that this type of subject matter was available for patenting. One thing that's fascinating if you read this decision is, what is the appropriate analogy to isolated DNA, and is there even one that we should use? So there was discussion for the majority about how, look, everything comes from nature. The fact something comes from nature, that in and of itself is not the issue. And cited things like drugs. There was also discussion of, well, it's like carving a bat from a tree. It comes from the tree, but it's very different. There was discussion about extracting minerals and elements from nature. It may be very labor-intensive, but that doesn't make it patent-eligible. There was a discussion of taking a kidney out of the body. Obviously, that couldn't be patent-eligible. And I know those are kidney beans, not human kidneys. It's hard to find human kidney clip art, it turns out. And then also there was an example given of snapping a branch from a tree. The dissent viewed that as essentially snapping a branch from a tree, and it shouldn't be patented. So it will be interesting to see if the Supreme Court, how the Supreme Court views this issue, and if it is concerned by the public policy issues that have really dominated the earlier discussions. So with that, let me turn to an additional issue as it relates to 101 patent-eligible subject matter, and this is the CLS Bank case. So far I've been talking about cases in the life sciences area, diagnostics, DNA. This is one more in the EE and computer science case. The Federal Circuit is going to be looking at this en banc in the coming months. This case gets at the issue of when we have abstract ideas and you're trying to implement them on a computer, how much is required of a computer and the hardware? Is any computer enough, or how much is needed? So that's another case to watch and to see if that case also makes its way to the Supreme Court. So let me turn now to the second major topic I'm going to address, and that's patent exhaustion. And this gets us to the Monsanto versus Bowman case that the Supreme Court will also hear this term. The facts there are that Monsanto developed and invented a type of soybean seed, which it called this Roundup Ready technology. What it did was genetically engineer the soybean so it was resistant to certain types of herbicides. It got all kinds of patent claims on it, composition of matter, method claims, and it sold the seeds along with a technology agreement. And under the agreement that came with the seeds, use of the seeds was limited to one growing season, and farmers were not permitted to replant anything that came from that initial generation of seeds. The one thing that Monsanto did permit, however, was crops that were grown from the seeds to be sold to a grain elevator and used as a commodity. And essentially what that means is it could be sold for things like livestock, things like that. The defendant in this case, an Indiana farmer, Mr. Bowman, he had bought some of the patented seeds and signed the technology license agreement and used those seeds pursuant to that agreement. There was no issue there. But what he also did was that he purchased seeds from a local grain elevator and he replanted them for several seasons. He was sued for patent infringement, and he defended on the basis of patent exhaustion. Basically, the principle that once a patent holder sells an article, that people who purchase it can do essentially whatever they want and then not be subject to a patent infringement claim. The district court disagreed on the issue of patent exhaustion, entered summary judgment of infringement, approximately $85,000 in damages. This issue has made its way to the Federal Circuit, and the Federal Circuit has affirmed the district court decision and viewed this as a conditional sale. And according to the Federal Circuit, the fact that the initial seeds were sold with these conditions attached, that was permissible. It was a conditional sale, and it precluded application of patent exhaustion. And interestingly, the Federal Circuit went on to say that even if patent exhaustion applied, it wouldn't matter because of the nature of the technology. And that was because these seeds are self-replicating technology. And essentially what the Federal Circuit said is every time there's a new generation of crops, it's a new infringing article. And so any patent exhaustion as to the initial seeds doesn't matter. So this decision could have implications for other areas of technology beyond crops. It could matter to cell lines, DNA, possibly in the computer space. So this is an issue that people are watching that will be decided by the Supreme Court. And it will be interesting to see what happens. Stay tuned. So with that, let me turn it over to Monty.
Thank you. Today, what I want to do is talk about joint infringement and some developments that occurred in August of last year in a case titled Akamai versus Limelight and a related case, McKesson versus Epic Systems. It's a decision that was argued in November 2011 and generated quite a bit of interest. 36 amicus briefs were filed on all sides of the issue. I think a lot of the industry saw the case as one that could potentially really expand liability under the patent laws, and some advocated for that, and some advocated for some restraint. And the decision, it's quite remarkable. It's 20 pages from a group of the majority, a 16-page dissent by Judge Newman, and another 15-page dissent from another group. So a highly divided court opining on joint patent infringement of method claims. So what I want to try and do, I never know if everyone is on the same board, is tell you a little bit about what joint infringement is so that you understand the concept, how to spot a joint infringement claim using the examples of the Akamai and McKesson cases, which are part of the decision, and then to just walk you through what it is that the decision does. I think what you'll find is the decision is sweeping in that it tackles a core issue of doctrine, and that issue is the single entity rule. It is ultimately somewhat narrow because it does not tackle it as a matter of direct infringement. It only deals with the issue as the concept of induced infringement. So let's work through this. Just to back up, the two workhorses of patent law are direct infringement, which comes out of Section 271A, and it simply says whoever makes, uses, sells, infringes the patent, and induced infringement, which is Section 271B. And in the slide that you're looking at, I have put in red the term whoever. The thing to recognize is that neither of these provisions really tells you is whoever a plural or is whoever a single. Is it one person that has to infringe all the elements of a claim, or is it more than one? And that is the issue of joint infringement. Historically, although no one's ever really come to deal with the question of is whoever plural or single, law has evolved, at least in direct infringement, that all elements must be practiced by a single entity. We will find case after case that repeats that rule. Single entity means, in your typical case, the patent holder sues, let's say, an entity. That entity, the patent holder has to say, that entity practices every element of a claim, in particular method claim, by itself, not in conjunction with others. In the induced infringement, we have the same whoever, and the rule has always been no induced infringement without a direct infringement. You'll see that repeated in the case law over and over. And what the effect of that statement is to pull into the induced infringement context the single entity. So again, someone says you are inducing infringement, somewhere in that chain you have to show a single entity is practicing all of the claims. Joint infringement occurs when all of the elements of a method claim, and we really are talking about method claims here, but a single entity doesn't practice all the elements. So sometimes there's 5 steps to the method. 4 steps are practiced by one, but the final step is practiced maybe by another entity. Well, I'm going to show you an example from the Akamai case of how this is done. Why does this arise? Well, it arises mostly because sometimes some patents, well, they're interactive, and you can sort of imagine in the world that we live today, interactive methods. You know, it's just about 2 people collaborating. That is the invention, you know, the means of collaboration. Sometimes the economics of the industry allow a particular step maybe to be contracted out, or that's how the economics just shape that industry. And then I'm going to talk about the manner in which the claims are drafted. Sometimes the claims have been drafted to call for sort of 2 parties doing something where they need not be that way, but that's how they've been drafted. I'm going to talk about that. But that's where it comes up. And this problem of joint infringement, I call it a problem, but sometimes known as divided infringement, sometimes known as split infringement, it arises principally in those database, IT, web methods, but I think you can also probably see this kind of thing in the medical diagnostic fields. So this is going to be a sort of not just one industry. Let's take a look at Akamai. If you know Akamai, Akamai was started in the telecom era. It's a web storage and content server. So essentially you would hire, if you had a website, you might hire Akamai, who has servers in all parts of the country, all parts of the world, to deal with overload demand situations. So all of a sudden your website goes viral, and they'll sort of store a copy of your website, all the little objects and pages, so that if there's an over-demand situation, then you can sort of default to them. Or maybe you really need speedy service and you don't want to create servers all around the world, so you might host your site on that. And Limelight does essentially the same thing, and it offers a competing service. So Akamai ended up suing Limelight on a patent claim. And what I've shown on the slide is the steps, the basic steps of the patent. And what the evidence showed was that Limelight practices all of the steps except one step. So step in red, it calls for tagging. And so Limelight defends this patent suit on grounds of divided infringement. It's not a step that we do. We do not tag the photos, the pictures, the drawings that are part of my web page. In fact, what Limelight does is it tells its customers, if you want to hire us, you tag it. And here's the instruction manual on how you tag it. The court, in the district court, the jury actually sides with that $40 million verdict. The district court says, forget about it. There's no infringement because there's no single entity practicing all of the steps. Akamai appeals. The court panel, the Federal Circuit panel, says, you're right. There's no infringement because it's divided. And the claim, and what the court says is, hey, you can have joint infringement, but it's very limited. You can say 2 entities are practicing together, but it's only if there's an agency relationship or a contractual obligation. So in this case, the infringement is by Limelight plus Limelight's customers. And the court says, hey, the customers are not agents, and they're not obligated contractually to do this yet. And I think even the panel that took the case says, well, it's kind of too bad because you're right. All the claims, the patent is definitely being practiced, but it's not by a single entity. But you know what? You can deal with that problem if you would just write your claims properly. So what are they talking about? Well, it turns out, all right, I can't move this forward. Could we? Thank you. What what they're saying is, you know what, that tagging step, you could have written it, and I kind of made this up, as receiving tagged information. If you had just written it that way, then it would fall into a single entity. So it's kind of a little bit of form or substance. But what you're seeing is the court saying we are sort of scared about extending liability to these joint situations. We don't know where this is going to go. That our view is that, hey, you just need to write this. But when you go back and look at the patent examiner's manual, there's no requirement that you draft your claims to fit within an entity or single entity. It just says, hey, you got to use ordinary language or as best uses and express it. There's no requirement under patent law that says you have to write your claims to fit one entity. And it may not even be possible in many, many situations. If you have a truly interactive technology, it might not be possible. So it was kind of a way out, but not very helpful for Akamai. Move for rehearing. And at the same time that Akamai is coming up, we have a case, McKesson versus Epic. And this is a personal patient medical records. McKesson owns a patent that, you know, essentially covers how doctors and patients can correspond with each other, sort of the idea of medical, electronic medical records. And McKesson sues a company called Epic that makes this software, which it sells to, for shorthand, a doctor who wants to talk to his or her patients. And the patent, and they sue for induced infringement. So Epic doesn't practice the patent. They just sell the software. So they say, well, your software is inducing doctors and patients to practice the patent. And there's one step that is not done by the healthcare provider, initiating a communication. That's initiating a communication by a patient. So it turns out the healthcare provider practices all the steps but never initiates communication. The initiation has to be done under the software by the patient. So Epic says, hey, the rule is you have to have a direct infringer. The direct infringer has to be a single entity, and there's no single entity here. We're out. And in fact, the court in the trial court says, you're right, no single entity, you're out. Because there's no agency between the doctor and the patient. There's no contractual obligation of the patient to use this system. Very limited view. Both of these cases come up for hearing, and the court on its own, recognizing some of these issues an order asking for briefing en banc of two questions. If separate entities perform separate steps of a method claim, under what circumstances would the claim be directly infringed? And in the McKesson case, if separate entities perform separate steps, would they be liable for inducing infringement or contributory infringement? And I think the last question is actually somewhat instructive. It says, does the nature of the relationship between the relevant actors, and they cite doctor-patient. So they're really concerned, I think, you can sort of sense that, what are we really going to open this doctrine up to having every patient all of a sudden become patent infringer? That's what they're worried about, is everybody who uses something, even though I don't know anything about this patent, never heard about this patent, all of a sudden going to become a patent infringer. Lots of briefing goes into this case, which is essentially consolidated for purposes of the en banc hearing. And here's sort of how it shakes out, as I mentioned, a very divided court, and one that took quite a long time. My colleague Bob Taylor and I wrote amicus for the pharmaceutical industry in this matter, and ended up with a lot of amicus briefs for filed. And it's very clear when you read this long opinion, a very dense opinion that goes back to first principles, even things like aider or abettor, criminal liability is cited, going back to testimony given in the 1952 Act, that there's two sort of competing problems. One is this concern about too much, extending liability too much. extending direct infringement liability in a manner that would ensnare actors who have no way of knowing anything. At the same time, real concern that, wait a minute, these patents are being practiced, and people can potentially just sort of arrange their economic affairs in a way where they're practicing the patent jointly but will escape liability, even though that may be the natural way the patent is practiced. It will leave the patentee without any remedy for what otherwise is a clear violation. So here's the expectation going into this decision is that we're going to get some grand pronouncement about direct infringement liability and induced infringement liability and the applicability, the continuing viability of the single actor rule. In the end, the court doesn't go that far. It essentially cuts on joint direct infringement. This is 271A liability. And it says, we're not touching that. So that rule stands still as the way it was, that you only directly infringe if there's an agent, if you're actually sort of contractually obligated, direction and control. On induced infringement, the single entity rule is now essentially, for all practical purposes, gone. What they have said is, if it's a method claim, a party that does not perform all the steps can still be liable if they knew of the patent, that's your basic knowledge requirement for induced infringement, perform the steps of method, or induce others to perform and all the steps for practice. So this is an expansion of the joint induced infringement, but still limited because of that knowledge requirement, of the specific intent requirement that's added to the joint infringement. So they really have hunted on one side, expanded a little bit on this on joint infringement, and hopefully curtailed what they think is the possibility of abuse by sort of pushing off on this idea of knowledge.
How is this different from what you used prior to the decision?
Yeah, so prior to the decision, you would still have to find a single entity practicing all this stuff. Now, it's enough that 1, 2, 3 people, we don't know the full range of it, but at least 2 we know. If 2 people are practicing, you could theoretically sue one or the other. Well, you know, you guys are working essentially as a joint enterprise. You know that the patent is there. So the single entity rule is essentially gone now. And this is really for method claims. We haven't seen it expanded for others. Although system and process claims have some different rules, but likely will follow a similar path. In the few minutes I have, I want to just highlight just how contentious this issue was. Judge Newman, who wrote 15 pages on his own, just this en banc court has split into 2 factions, his view. An all-purpose single entity, he basically said an all-purpose single entity requirement is flawed, but accuses the majority of punting on the issue, which they did, and he thinks it's just that the new inducement-only liability rule has really no purpose. So this is not going to be the end of this story. Judge Lynn wrote, along with a few others, he going back, he says, this is a congressional problem. They view the statutory scheme as some sort of integrated statement by Congress of when you are liable. And if you want to create a new rule for joint infringement, let Congress go and do it. Lots of other issues raised by the dissent. How do you split damages if one person practices only one element of a patent, but all the other elements are somebody else? So I think what you see here is a rule that's expanded. It's not as deep as people thought it would be. There's open issues about direct infringement, and we will continue to see how this rule comes about and how people enforce it. Now the joint infringement defense, divided infringement defense, is a little bit less of a defense. All right, thank you. And let me turn it over to Mike.
Thank you, Monty. Briefly,
So what I want to talk about today is how some damages issues. There's been a lot of damages decisions in the past several years out of the Federal Circuit, and they've provided some guidance. And I want to talk today about a little bit more guidance that has come out of the Federal Circuit, as well as how some district courts in 2012 have been implementing some of the previous guidance from the Federal Circuit, and how lower courts are viewing what the Federal Circuit said in particular fact situations. In order to, I just want to briefly do a primer on damages and how they work. Essentially, in patent damages, there's two basic models. One is your actual damages, which if you were a competitor and you lost some sales, you can prove you had lost sales, then you can get lost profits. Usually it's called lost profits damages. But there's a safe harbor or a minimum guarantee in the patent statutes under 284 that if you can't prove actual damages, then in no event should you have less than a reasonable royalty for the use made of the infringement by the infringer. And implicit in that language is the idea that the damages and the royalty have to be tied to, in fact, the benefit that the infringer got out of the use of the infringement. Lost profits damages follows a pretty reasonable and familiar to lawyers structure where it's a causation model, where if you have to prove you're a competitor, you have to prove that they sold something, you have to prove, which is sometimes can be a little unclear, how important the patent was with respect to that. But if you lost some sales and you have a causation model for your lost sales, then you can prove your actual damages. It's not super different than the way damages work in every case. It's the safe harbor, the reasonable royalty, that can get a little bit unclear as to exactly how one can prove up what a reasonable royalty is. And we've had, obviously, Georgia Pacific for many, many years, and everyone goes to Georgia Pacific as the list of the factors. But these days, I think perhaps coincident with the increasing complexity of consumer products, and perhaps also coincident with sort of the rise of non-practicing entity litigation, which is a reasonable royalty model, the Federal Circuit has paid more attention these days to reasonable royalties and exactly how you're supposed to figure out what that reasonable royalty is. So just some basics in the schema of what a reasonable royalty could be. Different models include a running royalty going forward on the use of the on sales by the infringer of the product, or you can also do a lump sum payment for freedom to operate with respect to whatever the patent issues are. Usually lump sum payments are a little easier to prove up because they depend on a licensing scheme for the patent holder or for the accused infringer. So those are going to depend on what the royalties, what the actual license agreements that have been either specifically or in the industry in this area. If you are going to do a running royalty, then the way it works is you have a royalty rate and you have a royalty base. And there's a couple of ways to do that. The rate can be a per unit fixed amount for a sale of a product, or it can be a percentage of the overall revenue of the product. And so these days, one of the important questions is, how do you figure out, one, of course, what the rate is, but then two, what's the base? What are you applying that royalty rate to? And the way this has typically worked before, not pejoratively, is you just have plaintiff's expert, and they talk about a bunch of stuff, they list a bunch of factors, and boom, you have a base and you have a rate. And then you have the defendant side, and they come in and they're all, wait a minute, factor, something, everything's lower. And it's been pretty much left as a battle of experts without a lot of clear guidance as to whether there are rules containing in what way you need to talk about the base or talk about the rate. And one of the more important limitations that has been recently battled on this issue is something called the entire market value rule. The entire market value rule is it's trying to in some way address this issue of apportionment, which is part of the damages statute, where what does it mean to be the use made of the invention? And so there's been a lot of case law over a long period of time agreeing that if an invention is only a piece of a thing, you've got to figure out what that value is. It's not the value of the entire thing. And so from that, then you get to this articulation of what's called the entire market value rule, which is if the product, the revenue base that you're trying to use is a lot, colloquially, just a lot bigger than what your claimed invention is, then in some way you need to tie the invention to that bigger product that's sold or revenue that's being made, because otherwise you're capturing something where there's a lot of other inputs into that large product or that large service, and there's a significant risk of overvaluing the actual patented invention with respect to the larger product. And so the way it's generally articulated is if your invention is a, quote, component of a larger product, then you need to show somehow the proportional value of that component in the larger product in order to get damages. So that's sort of where it's at, and then people would argue, well, I have, this is really important or that's less important, and here's my royalty rate, and here's my base. So the application of the entire market value rule has to do with, well, what does it mean to be a component? Is that the same thing as a feature? Where's the cutoff line as to what kind of a royalty base or amount of revenue you can use? Before a lot of the Federal Circuit decisions that came out in a few years were written, there was a case that I would point to that's been cited a lot called Cornell University versus Hewlett-Packard Company. And it was, I think, in 2009. And what's interesting about this case is it was in the Northern District of New York, but it was Judge Rader sitting by designation. And so it's a little bit of a preview of how this has ended up playing out at the Federal Circuit. And so in that case, Judge Rader gives essentially guidance, but it's a little bit negative guidance because he talks about what you're not allowed to do with respect to the entire market value. So briefly, the facts, and so you can learn some lessons here, and some of them turn out to be true later in some of the Federal Circuit decisions. It's a little bit of incomplete guidance. Going to the facts of the case, Cornell was suing Hewlett-Packard for the sale of servers. The actual invention that was issued there was a method patent, and it was a method of issuing processor instructions within a computer chip. The court said, Judge Rader said, they obviously didn't invent a computer system, and I think we can all agree to that, is what he says. And then he walks through exactly how the invention fits within the computer system. And so the way he explains it, this method of issuing processor instructions is one component of the buffer, which is one part of a processor, which is then one part of a CPU module, which is one part of a CPU brick, which is one part of a cell board, which is part of a server. And the plaintiff in that case, as plaintiffs sometimes do, picked the server revenue as their basis for damages. And the judge said that is a little bit of a problem because you're so far up the chain of value that we have no idea whether or not this patent is actually, the use made of the invention is being reflected. And there was I think there was a Daubert first where the judge said servers are off the table. And what the plaintiff then did was take one step down, or two steps down, I guess, and start talking about what the CPU brick revenues would have been, and then use that as the basis of the damages. So the court didn't like that. And the decision, but what's important about what the court said is there's some guidance here. And the court said, if you are going to do a damages model, you have to pick the smallest saleable unit as your base, whatever that might be. And if you're going to do something bigger than what the smallest saleable unit is, that implicates the entire market value rule. And if the entire market value rule is implicated, you then must show that for whatever the larger system is that incorporates the smaller system, that the patented feature drives the demand and is the cause of people buying the larger service. And so here, the purchase of servers, there was no evidence, this is kind of a new rule, sort of, there was no evidence one way or the other as to whether or not the method of issuing processor instructions was driving customers to purchase servers. And fairly, that would probably be tough to prove. But when I went through the list, the court looked and said, you're not without remedy, you still have to go to the smallest saleable unit. And what's a little bit interesting about this case is the smallest saleable unit was determined to be the processor. But remember, as the court explained it, the processor still isn't the invention. It's still got other components, but the court said, look, you just need to go to the next available level, the first available level of sales where you can figure out what the base could potentially be. If you go there, then by implication in that case, they didn't have to show something about demand. They could just use that, and he did, in fact, that on a JMOL, I think it was, and a remitter where Hewlett-Packard had offered a model using the processor as the base, and he just applied the found royalty rate to the processor. Didn't discuss whether or not you had to prove that the demand for the processor was driven by the patent feature, and just gave that as the damages. And so it's clear in its application on the facts of that case, but it does raise some issues of, well, you have to still apportion where it's still only one feature of whatever the smallest saleable unit is. But it provides guidance, and it provides at least some way of clearly limiting when too much, what too much is, and what to do when the plaintiff has sought a model that has too much in it. So, like I said, in general, models have to do with prior models for, this is my base, I know it's really big and there's a lot of stuff going on, but I've accounted for that, and now I've lowered the royalty somewhat to account for the fact that there's many things going on. And it's just a battle of the experts. And so these days, then the question is, well, how much of this is a fact question? Is there going to be any gatekeeping on what experts can do and not do? So into this system, post the Cornell case, the Federal Circuit issued Unilock last year. And Unilock gets a lot of press for, just briefly, the facts of the case where Microsoft had a copy protection feature that prevented people from using unauthorized copies of Word and Windows. Enormous amount of damages. And the way the damages, enormous, if not relative to the amount of revenue, but not a small amount of damages. The way the damages model worked in that case was they didn't actually take a percent of Microsoft's revenue. They just, the plaintiff's model in that case tried to figure out on a per unit basis what the right amount of dollar damages would be, and they took it and they just multiplied it by the number of products sold, and the jury came back roughly consistent with that theory. So it wasn't exactly an entire market value rule case, because the base, the royalty rate wasn't a percentage of revenue, it was just a fixed per unit cost. So the court, the headlines of that case are, of course, when they were coming up with justifications for why that revenue, that royalty rate was appropriate, there was use of the 25% rule, and Unilock is famous for dumping the 25% rule because it doesn't have, it may or may not in any particular case be applicable to that case. And the court decided there's no such general rule. You've got to go to the specifics on a case-by-case basis. But the other thing that the Unilock did was speak to some of these issues of the entire market value rule. And there, like I said, they didn't actually apply the entire market value rule in that case because they were using a per unit royalty rather than a percent of revenue royalty. But the plaintiff in that case did a couple of things. One, they did calculate what this would look like as a royalty rate by referring to the fact that Microsoft made $19 billion worth of sales of these products. And also, in the cross-examination of the defendant's expert, the plaintiff lawyers asked such questions as, well, if we use your rate, where it's like 0.00001% of Microsoft's revenue, is that fair for our plaintiff in this case who has an invention? And the court found you can't do that. You cannot refer to overall revenue, because once you start referring to overall revenue, you need to prove that you are entitled to use the entire market value rule. And in order to prove the use of the entire market value rule, you have to tie the invention to demand for the overall product. If you can't do that, you can't talk about revenue at all. And in that case, of course, it would have been hard because it's hard to imagine that consumers are demanding copy protection. Copy protection is certainly probably important for Microsoft to control piracy in its products, but it's not something that a consumer would demand. So it probably doesn't have that much to do with consumer demand, at least directly. And so there's having no real way to satisfy that, then basically Microsoft's revenue, according to Unilog, should have been off the table. It still leaves a couple of issues undecided in Unilog because, again, it's sort of a negative case. This is another thing that you cannot do. It's not really a proscription as to what you should do. And so into that framework, we had in 2012 the Laser Dynamics case. And Laser Dynamics came out in the summer, and it involves a plaintiff who had a patent on a particular part of the technology in an optical disk drive, and the plaintiff's damages model took a percentage of revenue off of the sales of laptop computers that included the optical disk drive. And in Laser Dynamics, in some sense, a lot of these cases, they make sense on their facts. The problem is whether you can extract a rule out of it. But in that case, the court said, look, the laptop computer is bigger than the optical disk drive. You need to go to whatever the smallest saleable unit is, and that's your appropriate base. If you want to talk about laptop computers, you need to prove that people are buying laptop computers because of the technology that is in this patent that is related to how optical disk drives function. And the court went through an entire litany of how not to prove that, but it's not enough to say that it's valuable, important, or essential, because all of those things are true about everything. Computers need screens. Computers need keyboards. Those are essential to computers as an input, but those don't, strictly speaking, drive the demand of a computer. Therefore, they should be off the table with respect to the entire market value. And so the requirement is quite high, really, that it's the presence of that particular functionality is what motivates a customer to buy the larger product. And unless you can prove that, you cannot be talking about the revenues of the larger product. Now, the case was a little bit interesting because the plaintiff said, look, you know, we have some industry examples of where it's quite common to have licenses that are off of laptop computers, and so why can't we use that? And they pointed to the fact that it's a little bit, it can be hard to derive pricing for the optical disk drive alone, and so if in the absence of pricing, then it's going to be an imputed price for the optical disk drive, and so there's so much uncertainty here. Everyone knows how much laptop computers cost and what the revenue are. That's why we did the model the way we did it. Federal Circuit didn't really care, and especially in that case, there was some evidence of what pricing for optical disk drives would have been. Federal Circuit said, look, it's the smallest saleable unit because somewhere it has been sold. Therefore, that's how you have to do your model based on what the optical disk drive pricing is. So again, it's helpful on its facts, but it's a little unclear how to extract a rule out of that unless you have quite similar facts. And the questions that are left open a little bit is, well, how do you prove up consumer demand under this new height standard? There's questions that have been raised following that about how to get around application of the entire market value rule by talking about lump sums or talking about a fixed unit cost as the royalty rate rather than a percent of revenue. And then this issue of what's the smallest saleable unit, which is sort of related to the idea of if there isn't a smallest saleable unit, exactly what are you supposed to do? Do you have to then prove essentially apportionment where it is no doubt a small feature of a large product, but the large product is the smallest saleable unit? Are you off scot-free in that circumstance talking about the revenue of the larger unit? So there's been a fair amount of district court activity wrestling with some of these problems and more. And I just want to walk through a couple of those, not in a, just to try and report the facts of these. A lot of these cases are ongoing. I don't take a view as to whether they're rightly or wrongly decided. I just want to raise some of the decisions that have been made by some of the district courts in light of this precedent and how different courts are grappling with the issue in their own ways. The first is there's a case in that people may have heard of in Illinois between Apple and Motorola,
where Judge Posner was sitting by designation, and he did. It's a very interesting opinion, and you should probably read it. It's to some extent pretty far to one side on the spectrum of. I think I said I was going to make editorial comments, so I'm not going to make them. But it's a pretty interesting opinion. He threw out all the expert testimony, and I believe they agreed that there's no case going forward, and so it's now on appeal because he struck all the damages reports. Not all of them, but enough of them so that it became difficult to have a case going forward. A couple of these issues touch upon issues of, well, one of the things I was talking about is what does it mean to have proof of customer demand? And in one of the ways in which he rejected some of the expert testimony, one of the experts in the case used the other side's survey of likely features to talk about showing importance. And it wasn't, I guess, it wasn't to show demand for the feature as much as it was to show apportionment of the value of the invention to the overall product. And so it's a little bit different, maybe, than the entire market value rule because it was basically trying to apportion out the value of the invention to the overall product. The problem that Judge Posner had with it is that even though it was the other side's customer survey, and so it's clearly admissible and it's an admission and it's good evidence, it didn't, to him at least, answer the question presented of isolating this particular inventive aspect of the patent at issue from other things, and so it asked the wrong questions, and therefore, even though it's an admission, and even though it's the other side's statement, he didn't find it useful. So it was a pretty high bar, and the patent feature, I can't exactly remember what the patent feature was, but the attributes that the expert was using to sort of try to figure out a way to apportion value were things like appealing features and functions of the product, and so there was a certain percentage of respondents that liked that, and then there was a further narrowing of apportionment based on this feature and how important it would be to people who liked features, and so there was math done to get to, well, I think this is the value of the overall product that's attributable to the invention. He didn't get into if that's an okay thing to do. He just got into, I don't like that survey. I don't think it answers the right questions. You're using the wrong survey. I wouldn't, essentially it says, I wouldn't do this, therefore you shouldn't have done it, and he throws it out. The other thing he says, there's other issues in there that are interesting where he basically takes the position that if you're going to be an expert, you need to act as if you're acting for the other side and come up with an opinion. And those are the only types of opinions that are reliable. So he says, look, you can't ask your own engineers about a design around cost. You have to ask the other side's engineers or take an industry survey or something like that, because that's what people, in his view, would do in the real world. Only the real world counts. And by the way, if you're going to use design around costs, it's not even expert testimony anyway. You can just have an engineer come in and do it. And so it's a little bit hostile, I think, to experts. And it's on appeal, and so it's not clear exactly what's going to happen with respect to it. But it's an interesting read, is what I will say about it. There's other less controversial cases out there. There was the Honeywell case, and that's actually just a case in the Court of Federal Claims where someone was suing the government for infringement based on the supply to the government by another private party of what they contend to be an infringing article. Pretty straightforward. It's an easy case to see how this would apply on easy facts. The patent had to do with a method for enabling an airplane cockpit to allow a full color display even if you had your night vision goggles on. So that's what the patent had to do with. The court there threw out both sides' conclusions, I guess I would say, and found its own conclusion with respect to what the right measure of damages are, but did note in passing, I reject the idea that you can talk about damages with respect to this cockpit display by pointing out to me that C-130 aircraft costs a lot, and therefore this is entirely reasonable. So, and the court also pointed out press releases talking about a feature aren't enough to show the laser dynamic standard of driving demand, which is what the standard is. It has to drive demand, not just be a feature you list as a part of the product set. Another case on these issues is Multimedia Patent Trust versus Apple. There, it's a Daubert case decided in the Southern District of California quite recently, had to do with video compression patents. And here the court does expressly draw this distinction between a fixed per unit running royalty from a percentage-based, i.e. percentage of overall revenue royalty rate. And the court says when you're doing a fixed per unit running royalty, that doesn't really or shouldn't really implicate the entire market value rule per se, because you're not talking about the entire market value. You're just talking about a per unit running royalty rate. Unclear whether or not that answers the question of how to apportion in the world of a fixed per unit running royalty. But it does say the rules that the court understood to be announced around the entire market value rule themselves don't really apply. But the court did point that if you're going to be talking about the percentage royalty rate as a check, which was essentially what was done in Unilaw, that's not legal. You can't talk about revenue at all. You can have a model that's fixed per unit running royalty, but if you're going to do that, no discussion of overall revenue, because then you get into issues of prejudicing the jury by talking about Microsoft's $19 billion or whatever it is. There's some other interesting things in there about how lump sum payments work and the propriety of being able to go from a lump sum payment to a fixed per unit rate. The court found that that was okay, and so there's math allowed, but it really just talked about this idea of the check. If you're not going to use revenue as your model, then you can never really even refer to revenue, because there's an issue there with respect to prejudicing the jury. Another case on this issue is the practice matter, which came out just before laser dynamics, and in that case it had to do with cell phone antenna. And it was interesting because the expert in that case tried to do an apportionment model, and they used the revenue with respect to cell phone sales and then said the percentage importance of the antenna to the cell phone, I'm calculating that based on this and that and other inputs, and then I'm going to take that calculated value and use that as my base. But it's a percentage of the overall sales of the cell phone. I think it was 10%. 10% of that is really the true value of an antenna. When you get to that, then that's a dollar figure, then I can take my royalty off of that. And it's a little bit of a two-step process, because it's not actually using the revenue of the cell phones, sort of. And the court said that. The court said, hey, they're not using the revenue of the cell phones. They're doing apportionment off of the revenue of the cell phones. But that's not the same thing. And this is an apportionment model. And so when they do the apportioning, then you can use the smaller amount as your revenue base, even though it was based on a larger revenue base. And the thing that's interesting in that case is it's not completely clear that that would survive post-laser dynamics, because there was evidence in that case of actually how much cell phone antenna sells. And as it turns out, the imputed calculated value was something like 16, 14, something like that, dollars for an antenna. And the actual sale price of antennas was $1.50 or $1.60 or something like that. And so it lines up pretty nicely with the laser dynamics case value, where there is an actual price for the antenna. You've got to use the actual price. The court recognized this in a footnote talking about the Cornell case and says, look, I hear you, but he did an apportionment here, and an apportionment is a way to go. And if you just take the sales price of the antenna, that may be unfair, because the plaintiff here is a startup. And it raises the interesting question of, do you have to use the smallest saleable unit, or can you just instead sidestep the issue and do an apportionment? And which one trumps, where you do the work to do an apportionment, but there is a small saleable unit, which wasn't really answered by laser dynamics, because they really just did, they just sort of ignored it. And so it's unclear how that's going to play out, but under laser dynamics, it would seem as if there's a sales price for the smallest saleable unit, you have to use it, regardless of the status of the company as a startup. The last one I'll point to is this ABM case, which is a pretty interesting case, because there's a little bit of a tension here between the issue of apportionment and components and features. And the plaintiff in that case did what they argued exactly they were supposed to do. They went to the smallest sellable unit, which was the microprocessor, and they said, this is the smallest sellable unit, that's our base, we are taking royalty off of that base, we should be clear under laser dynamics, and we should be clear under Cornell. But the defendant pointed out, well, yes, the microprocessor may well be the smallest sellable unit, but this is still not, the invention isn't coextensive with the microprocessor. It's still a feature of a microprocessor. And if you go back and you look at the Lucent case, which was that date picker case for Microsoft Office, they're all, hey, that was the smallest sellable unit, Microsoft Office, but a date picker is really small, therefore you should still do apportionment even if it's the smallest sellable unit. The court acknowledged that those two ideas are in some tension, and basically sort of said, I'm inclined to go on Lucent on this because this is so small compared to a microprocessor. So again, a lot of these things are clear on that fact, and your question then would be, which am I? Am I a date picker in Microsoft, or am I sort of like a CPU brick, and like I'm sort of more important than just a date picker as to whether or not the smallest sellable unit is for you a solution for a damages model if you're a plaintiff. So just those are sort of some of the questions that are still out there on damages on these issues. Is it a valuable model to just go to the smallest sellable unit? Seems like it should be, but some courts are having trouble with that where it's a really small component of the smallest sellable unit. Do you still have to do apportionment? And if you don't do apportionment, does that mean that you don't have a model at all? I would just point out at the end of this that a lot of these questions can be solved to some extent by using licenses, because licenses are either, and one of the courts pointed that out, licenses either apply or they don't apply. If they apply, then you can do what the license did, because that's where contracting parties did exactly what you're saying. And so you don't have to get into all these how to apportion revenue questions, because if someone else has done it already in a arm's length negotiation, then you can point to that and use it as a license. So all these things are sort of trending towards the idea of licenses are just becoming much more paramount and much less subject to challenge than anything else. And with that, I will hand it off to Tom.
A great segue, because I'm here to talk about licensing. I'm the humble licensing lawyer in the group, and you've heard some cases that are interesting to patent prosecutors, some cases that are really most relevant for patent litigators. I'm here to talk about a series of cases that is more relevant for IP transactional attorneys like myself, although there's some tidbits in here that are useful for litigators to keep in mind as well. I want to talk to you today about implied patent licensing as opposed to express patent licensing, which I'm sure you're all familiar with. What is implied patent licensing? It's when a patentee who has already granted a license to someone else is barred, essentially, from asserting different patents against that licensee because doing so might derogate from the value of the earlier license that the patentee granted. And I'm going to use, there are cases here about licenses and there are other cases about covenants not to sue. For our purposes, they're the same. The courts have basically said they're treated the same for implied licensing analysis. Why should you care about this? The doctrine of implied licensing is old, but it has been expanding in recent years. It's becoming more important to understand not only what's on in four corners of your license, but also what the case law might read into it for purposes of, for example, valuing patents either in your portfolio or patents that you think you might want to acquire or obtain exclusive licenses to. And the cases have evolved to the point where I think we can give a bit more guidance than we used to be able to give on how to avoid granting an implied license if that is your goal. The doctrine is old. It started at least 40-something years ago in a case called AMP versus the U.S. In this case, which was primarily about a research and development agreement with the U.S. government, the developer had granted a license to the U.S. government to practice, quote-unquote, the subject invention, which in this case was a wire splicing device. I didn't realize that you could still get a patent on a wire splicing device in 1968, but I guess you could. And in this case, the licensor granted this license and then acquired from another company an earlier filed dominant patent. What do I mean by dominant patent? I don't mean one that's pushy. I mean one, that it was necessarily infringed by the practice of the subject invention. There was no way to practice the subject invention without infringing on this earlier patent. Well, once the licensor obtained this patent, the licensor sued the licensee on the dominant patent. And the licensee said, wait a minute, you already granted me a license on this invention, and I don't care that you have this new patent. I still should be allowed to practice the invention. And the court agreed, and the court claims in this case that this is a U.S. government licensee. The court claims that yes, the licensor should be stopped from asserting that dominant patent because asserting that dominant patent takes away the value that was granted by the earlier license. This case sort of sat around for 40 years and nobody paid all that much attention to it because there was a concurrence in the case that found a different reason for reaching the same result that most people thought was the right reason. And that was that the license that had been initially granted was to the subject invention, not to any particular patent. It said, any rights I have to this technology, you have a license to. So it was easy enough to find that the license on its own terms granted a license to whatever patent the licensor held and not to any particular patent. Most people thought that was the better holding, but it was technically the concurrence. Fast forward 40 years to the case of TransCore versus ETC, Electronic Transaction Consultants. This is a case about electronic toll collection systems like EasyPass. TransCore and Mark IV are competitors in this space. They had some earlier patent litigation that was settled with a covenant not to sue, from TransCore to Mark IV, and it covered several patents held by Mark IV. That covenant not to sue on its own terms said it shall not apply to any other patents issued as of the effective date of this agreement or to be issued in the future. Most licensing lawyers would tell you that's clear enough. It only applied to the patents listed in the covenant. It did not apply to any other patent. ETC, totally unrelated company, went ahead and installed and tested some EasyPass systems purchased for the Illinois State Toll Highway Authority. Those systems had been purchased by Mark IV, effectively the licensee of TransCore. TransCore was not daunted. They went ahead and sued ETC on 4 patents, 3 of which were included in the covenant not to sue that was held by Mark IV. And part of the opinion actually is about patent exhaustion and whether patent exhaustion applies when you have a covenant not to sue versus a license. And again, many people would have told you it doesn't apply, that a covenant not to sue did not exhaust the patent, and TransCore should have been able to sue ETC. In the Federal Circuit's opinion, they said, no, that's wrong. A covenant not to sue is basically a license, and so there's no right to sue on those 3 patents. I'm not here to talk about that part of the opinion. The part I want to focus on has to do with the one patent that was not the subject of the earlier covenant not to sue. That patent was, in fact, dominant over one of the other patents that was the subject of the covenant, meaning you could not practice that patent that was covered by the covenant without infringing this other patent. And that patent was an application at the time that the covenant not to sue was executed. And in fact, it was pending, but Mark IV didn't know that this application was pending out there, and so didn't know to ask for it in getting the covenant from TransCore. What did the court hold? The court held ETC had an easy path to the dominant patent, the illegal estoppel. Basically, the court made short shrift of the language saying that the covenant did not apply to any other patent. It said, no, that doesn't really make sense. Mark IV, if they had known about this other application, would have wanted a license to it, and so we're going to just act as if they had one. It's a very, very surprising result for a number of reasons. It, went against the express intent of the parties. Also, because the earlier covenant was a settlement of litigation, there's a doctrine, a body of law around settlements that basically says courts are supposed to interpret settlements very, very narrowly. They're supposed to be limited to the express terms of the agreement because the parties are at odds with one another. They're fighting over every word in the agreement. You're not supposed to read a whole bunch of stuff into settlement agreements, but the court went ahead and did that here, and so it's very surprising to a lot of people in this space. We were all hoping there would be a little bit of clawback from this opinion, and we didn't really get it because in the next case, which came out 2 years later, General Protect Group versus Levitin, this is a case about ground fault circuit interrupters, those bathroom outlets that protect you from electrocution. Levitin GBT again had settled earlier litigation with a covenant not to sue from Levitin to GPG, covering 2 patents and 2 patents. Only, again, the covenant said it only applies to these 2 patents, doesn't apply to other patents. Levitin was then later granted 2 narrower continuations of those patents, meaning that there were ways to practice the patents that were covered by the earlier settlement without infringing the 2 continuations. So it's a different situation. There's no dominant patent situation here. There were ways of practicing those other patents without infringing the new ones. And so Levitin sued on those 2 narrower continuations, saying you don't have a license to those. We only give you a covenant on other patents. And the court said, no, again, even though they're narrower, and even though you could practice those patents without infringing the earlier ones, the doctrine of implied licensing applies nevertheless. These patents are related to the earlier patents. There should be a license implied to them, and there was no clear indication of mutual intent to the contrary in the agreement. And it is those words of the opinion that we licensing lawyers now hang our hats on. Obviously, the focus on the clear indication of mutual intent to the contrary suggests that you could draft language that the court would actually honor, something more than just this license only applies to these patents and it doesn't apply to any other patents. What language would work? We don't know, because the courts have not actually found any language that they were satisfied with. And I want to talk to you about one more case before I get to some tips that I think you might consider in drafting patent licenses. And that case is Intel versus Negotiated Data Solutions. This is a little bit of a different issue, but this case focused a lot on TransCore and Protect. Intel and National Semiconductor had cross-licensed each other under all patents with the first effective filing date prior to the expiration of their agreement. So the licenses were perpetual, but they only applied to patents that had effective filing dates prior to the expiration of this agreement. The patents that National had at the time went through a series of acquisitions. They got transferred to various unrelated entities, and one of those entities filed broadening reissue applications on those patents. So they tried to get broader claims than those that were in the original patent. After the agreement with Intel expired, Vertical, which was then the patent holder, assigned those patents to a company called NData. So the agreement's long done. NData now gets these patents with these broadening reissue applications pending. The reissue applications eventually do issue, and NData takes advantage of that and sues an Intel customer, Dell, on the reissue patents. Intel actually intervened in that case and said, wait a minute, Dell is our customer. We have this cross-license with National that applies to the patents that these reissues were issued on. The license agreement should cover us, even though the license agreement didn't say anything about reissues. What did the court hold? The court held, in the absence of contrary language, again, that key phrase, the patent license is not directed at specific claims or a specific field of use or has other sort of limiting language, and it will extend to the full invention that is the subject of that patent. And the court looked at the language in the Patent Act, 35 U.S.C. 251, that deals with reissues. And that language says that a reissue is not entitled to any new subject matter. The subject matter of the reissue must be the same as the subject matter in the original patent, even if the claims are drafted more broadly. And they said, since it's not a new patent, because there's no new matter, the license should apply. Okay, so what lessons can we take away from these cases? Clearly, if you're the licensor, you want to disclaim all implied licenses by legal estoppel or otherwise. We don't know if that will actually work, but you should at least give it a shot. You should avoid granting licenses to inventions that are disclosed in the patent several of these cases focus on that fact that the licenses were to an invention as opposed to specific claims or specific patents. It would be a really good idea to require the licensee to acknowledge that no license is granted to any other patents, whether or not those patents are necessarily infringed by practice of the licensed patents. I think that is the key language. If you can get the licensee to acknowledge that the licensor might have patents that are infringed by practice of invention in the licensed patents, and they understand that and they're willing to take that risk, I think it would be really hard for the Federal Circuit to ignore language like that in its agreement. And of course, you should expressly exclude any continuations, reissues, divisionals, continuations in part, whatever other types of patents that you intend to exclude if that is in fact your intent. There is a question. You want me to answer it now? I have one more slide. Okay. Now, if you're the licensee, what should you do? Exactly the opposite. You shouldn't rely, you shouldn't rely on legal estoppel, even though it seems to be working really, really well for many licensees here. It's better to do your due diligence ahead of time, try to figure out what patents are necessary from the licensor's portfolio and get express licenses to those. You don't want to be the test case where something fails here in this realm. You should try to get a license to the inventions that are disclosed in the licensed patents, so the licensor can't play tricks with how they draft their patents. You should include continuations, reissues, divisionals, etc. Maybe even get a warranty from the licensor that says the licensor holds no other patents that cover the licensed invention, so that if later there are some, you can at least sue for breach of warranty. And you should include all current and future patents held by the licensor that are necessarily infringed by practice of the licensed patent. Again, no guarantees that any of this will actually work. It's an evolving area of the law, but we think the Federal Circuit has hinted that it won't actually completely ignore the express intent of the parties as long as it's sufficient. Okay, so it sounds like we have at least one question. And the question is, would the typical covenant not to sue bar state law fraud claims, like fraud in the inducement, where it could be shown that the licensor was delaying or postponing the issuance of a dominant patent? The person's thinking about subsequent divisions or continuations. It's a very good question. I think that TransCore was a bit of an example of this, although it never reached the fraud level. It's a case where the facts suggested the result. It seemed like TransCore had concealed the fact that it had this continuation pending at the time that the first lawsuit had been settled, and so the court wanted to find a way to get that patent covered by the covenant not to sue. That seems to be what's going on there. Could you actually bring a fraud claim? I guess I would leave that to the litigators. My advice as a transactional attorney would be get the express warranty that says there are no other patents or applications pending that cover the technology that's being licensed. And if you get that, then you will have a breach of warranty claim should it turn out that there is some patent out there that you weren't aware of. Yes, certainly the concealment of the patent application would be a bad fact that might be persuasive to a jury, if not to a judge. I don't know if any of the litigators have any further thoughts on fraud or fraud in the inducement in the settlement context.
Yeah, I guess my own view is you would need to show some sort of express representation or something like that. So I think you would want to have dialogue when you were doing the license about what else was out there from the IP side and really explore that. And then I think from the transactional side, you'd want to make sure you got reps and warranties as to that. But I think absent any discussion like that, it might be hard to prove a fraud claim.
Yeah. Do we have any other questions, not only about my topic, but about any of the other topics that we're covering today?
This is from Mike, I guess, on the damages question. The enforcement conundrum might be addressed if there is a perfect comparable license agreement or set of license agreements for maybe the patent suit. But the Fed Circuit has also recently pronounced that it would better be extremely comparable. So once again, these negative pronouncements are making it harder and harder for experts to come up with some method to solve that conundrum. But what do you think the Fed Circuit is going to allow? I mean, the couplability has to be very, very strict now.
So, I mean, to some extent I agree, although, again, this is a problem of facts and then the decision following those facts, and then what are the rules out of that decision? Because a lot of the decisions that have been reached with respect to licenses are reasonable on their face. In the case about the optical disk drives, there was an exclusion of a particular settlement and an allowance of all the other settlements, and the agreement that was excluded wasn't excluded because it was a settlement, it was excluded because it was on the eve of trial and it was way out of line from the others. And so you can look at that and say, in that case, I mean, the rules so far on licenses, and there's a RescueNet decision where, even though it's a settlement, it's okay to use, it's been, with respect to the question about licenses, do something that seems reasonable to the Federal Circuit. And that's kind of the rule that we have right now. And, like, what's reasonable, I mean, on those cases, what they're saying is reasonable. And so don't do those things, because those weren't reasonable. In a case where there is no small saleable unit, and in a case where there are no applicable licenses, and there are those cases because there are a lot of patents out there and there's a lot of products out there, and then the question is, what are you supposed to do in that world? And a lot of these, when you read the decisions by the Federal Circuit and the district courts, express little sympathy for that set of facts. But in those cases, there's generally another set of facts that were available that they basically would have preferred. And so I don't know what the answer is in a case where there's no applicable licenses and when there's no small saleable unit. But if you go back to Lucent, you're going to have to do some sort of apportionment, and there's going to be a lot of math in there. And I mean, one of the ways to answer this is to do a customer survey, which is an expensive and painful process, where you actually have to go out and interview people to determine what customers would say was driving demand or what was important to demand or how to assign a value to that thing. And that's always potentially one option. But customer surveys, I mean, in the world of trademark services, but they're constantly challenged as being inadequate to the question presented, and they're always being thrown out. I have a feeling that in a case with no analogous licenses, with no small saleable unit, that's where we're going to end up, is you're going to have to do a customer survey to figure out what's going on in that case, where the invention isn't really particularly coextensive with the product being sold.
Well, I would agree in many respects, but it might also be the case the customer survey might not always solve that. These patents have been met by such minuscule and imperceptible part of complex thing. Even a survey, even the best content analysis, which are very expensive and always subject to criticism, would never really quantify it. Yeah, so the Fed Circuit told us all the things we can do.
Yes. And that list is growing longer.
So in terms of patent claim drafting, if you've got one of the little feature of the microprocessor, you actually make a claim to a microprocessor with the feature or the server with the feature. Is that a way of, a useful way, in a practical sense, of getting base that's the server that's a feature that's this patentable feature?
Yeah, so that to some extent came up a little bit sideways in the Cornell case, at least, where the claims were and the court there, being Radar, went sort of to his view of the truth of the matter, and he said, look, everyone should agree, if they don't, that you haven't invented a computer processor or a server or this or that. And he pointed to, interestingly enough, in that case, the title of the patent as evidence that what they were inventing there was a piece of instructions for use for a computer rather than a computer system. And so that evidence could be used to sort of defeat the idea that you invented something larger than a feature. And I can imagine that if you were going to be careful, at least you should be careful how to phrase things so that can't get used against you.
You claim the C-130, but include the clock.
Exactly. Right?
Well, it's 10 o'clock, so we should probably wrap up.
Yes, thank you all so much. We really appreciate your attending. And as I mentioned at the beginning, you'll be getting a copy of the slides. And if you have any questions, certainly feel free to reach out to any of us.
Thank you.
But on the other hand, an application of a law of nature or mathematical formula could be patentable. The court also looked at the competing public policy, which is that you don't want the grant of a patent to tie up laws of nature and inhibit future innovation, but you also want to reward those who make discoveries and innovate. So to decide the issue, the court dove into a typical patent claim, and it was agreed that this claim that you see here, Claim 1, was representative. And the court looked at the limitations. There was a step dealing with administering the drug. There was a step dealing with determining the metabolite level in the blood. And then there were where-in clauses where the certain metabolite levels indicated a need to increase or decrease subsequent administrations of the drug. And the Supreme Court put it this way. The question before us is whether the claims do significantly more than simply describe the law of nature. Do they add enough beyond their statements of the correlations to allow the processes to qualify as patent-eligible processes? Went on to say we believe the answer is no, because any additional activity in the claim beyond the law of nature was well understood, routine, conventional activity already engaged in by the scientific community. So the question that we will have going forward is whether courts apply this to other types of subject matter beyond laws of nature, and whether this is applied to composition of matter claims. We don't have to wait very long to see what will happen in that regard, because that takes us to the Myriad case. Now, Myriad is a case that you all know. It's probably done a lot of publicity. The claims there involve aspects of the BRCA1 and BRCA2 breast cancer genes. Basically, it was discovered that alterations in these genes indicate a propensity of women to have breast or ovarian cancer. Myriad, who was a patent holder in this case, had done quite a lot of work and put a lot of money into sequencing these genes and patented various aspects of it. Myriad also had an aggressive history of enforcing their patent rights. And essentially what they did was try to prevent anyone else from providing commercial diagnostic services to see whether women had alterations in these genes. And there were a number of issues that were raised. They were selling the test for quite a lot of money. They weren't taking all forms of insurance. And essentially the argument was raised that if a woman got a positive test result and was considering something drastic like a mastectomy, the patent rights foreclosed women from getting a second opinion, from going to somebody else to get the test done. And so there were a lot of plaintiffs who joined this case. There were medical associations, patients, doctors, and the petition to the Supreme Court was being funded by the ACLU and the Public Patent Foundation. The Supreme Court indicated just a couple of months ago that it will hear this case and it will decide question number 1, which is phrased as, are human genes patentable? So let's look at the Federal Circuit decision, because this is obviously what the Supreme Court is going to review. The Federal Circuit looked at this case twice. It decided the case once, and then it went up to the Supreme Court, who remanded it in view of the Mayo decision. The second decision was 2-1, authored by Judge Lori, and there.
Good day, ladies and gentlemen, and welcome to the Patent Law webinar. I would now like to turn it over to Ms. Jennifer Sklenar. Please proceed.
So with that, let's turn to the subject matter of the presentation. I am going to go first and talk about some issues of patent-eligible subject matter and patent exhaustion, and then we will have Monty Agarwal, who is going to be talking about induced infringement, and then Mike Berta, who will be talking about patent damages issues, and finally, last but not least, Tom Mignani, who will be talking about implied licensing issues. I also wanted to mention that we have a program tomorrow in person in Los Angeles, also available by webinar, which will focus on subsidy issues in a similar type of way. So with that, let me turn to the first topic, patent-eligible subject matter. And this, as I'm sure many of you know, is an issue that's of great importance and interest to the U.S. Supreme Court. The Supreme Court is active in this area. There was a case last term that I'm going to talk about, the Mayo or the Prometheus decision that involves laws of nature. There's the case that the Supreme Court is looking at coming up involving aspects of human genes. This is an area that raises not only constitutional issues and statutory issues, but also issues of public policy and morality. Jonas Salk was famously asked in the mid-50s by Edward R. Murrow, who owns the patent on the polio vaccine? And he famously answered, there is no patent. Could you patent the sun? And now the story goes that actually the lawyers at the Salk Institute did look into patenting the polio vaccine, but thought that they had prior art issues. And for that reason, the Federal Circuit reversed in part and affirmed in part on the issue of patent-eligible subject matter in view of Mayo versus Prometheus. And here, there were three different sets of claims that were at issue. There were composition of matter claims that were directed to the genes themselves. The Federal Circuit held that those were patent-eligible and were available for patenting. There were method claims directed to screening potential cancer therapeutics by assessing changes in the cell growth rate of transformed cells, also patent eligible, and then there were method claims directed to comparing or analyzing DNA sequences, which were held to be patent ineligible. Now, I'm going to focus on the composition of matter claims because that's really where most of the controversy lies, and that's what the Supreme Court is going to decide. For the composition of matter claims, there were actually three different types. There were the isolated DNA claims. And isolated DNA, for those of you who don't know, is basically a process whereby DNA has to be extracted from the cell, separated from proteins, other genomic materials. It's a complicated process, very labor-intensive. There were also claims directed to shorter molecules that could be used with things like probes and primers that corresponded to portions of the gene. And then there were cDNA molecules, which are man-made, but have some correlation to the native DNA, but there's a difference in that it excludes the intron portion of the DNA sequences. So on the first type of claim, isolated DNA, there was a reason they didn't do that. Whether that's true or not, this sentiment that's expressed by Dr. Salk is one that we often come upon, and it's essentially a sentiment that's argued quite a lot in these cases. So with that, let me turn to the Mayo versus Prometheus case. The patent claims there were in the diagnostic space. There were claims that were method claims, and it's important that these were method claims because that may matter for some of the case law later. But there were claims to assist doctors determine the appropriate dosage of thiopurine drugs to treat patients with autoimmune diseases such as Crohn's disease. And Mayo, was the accused infringer. It had been buying the test from Prometheus and using and selling their test for quite a while, but then the Mayo entities, including like the Mayo Clinic in Rochester, wanted to sell and began using and selling their own tests. It was somewhat different, but still arguably fell within the scope of Prometheus's patent claims. So Mayo was sued for patent infringement, and it raised the Section 101 challenge. And there the issue was that the claims touched on a law of nature, which was the relationship in the blood of certain thiopurate metabolites, and the likelihood that a dosage would be effective or result in side effects. So this issue made its way to the Supreme Court, and how did the Supreme Court decide this issue? In a 9-0 opinion written by Justice Breyer, the Supreme Court first looked at the competing legal principles. And those are that laws of nature, natural phenomena, and abstract ideas are not patentable